This is episode 28 of Lawyered. I'm Hussein Panju. This week I'm speaking with condominium lawyer Denise Lash about the legal issues facing condo managers and unit owners. First up, we're talking about Airbnb and short-term rentals. Converting your unit into a makeshift hotel room has never been easier, but we'll talk about the legal restrictions for condos and whether municipalities will step in to enforce. Next, we'll speak about the new statutory rules regarding manager licensing. While the proposal was sought to professionalize the work of condo managers, we'll talk about the legal implications and what boards of directors should be mindful of. And finally, we'll chat about the business judgment rule in the condo landscape. A recent appellate case appears to give plenty of deference to the decisions of condo boards, and we'll find out about the remaining recourse for unit owners. All that and a lot more is coming up in just a bit. This is Lawyered. Hello again, and welcome to episode 28 of Lawyered, the show where top Canadian lawyers take a critical look at current legal issues. On our last episode, we had a fascinating chat with children's lawyer Susan Fraser. We spoke about secure isolation and solitary confinement, parental refusal of medical treatment, and also a new child-focused legal paradigm. And that discussion taught me a lot about our child welfare and youth justice system, and so if you find it interesting, make sure you check that one out too. And before we get to today's show, remember that you can always subscribe to Lawyered for free on your favorite podcast app, and can also follow us on LinkedIn or on Facebook, and our Twitter handle is @LawyeredPodcast. And with that said, here's today's show. And my guest for this week's episode is Denise Lash. Denise is the founder of Lash Condo Law in Toronto and has over 25 years of experience as a condominium lawyer representing clients in all areas of condominium law. She is known for her effective dispute resolution methods in dealing with issues between condominium corporations and developers, as well as resolving complicated issues faced by her condominium clients. She has been recognized for her work on both the provincial and national level, and is a writer, lecturer, and is sought after by many media outlets for her condominium legal knowledge, and has written for a number of publications, including her own blog called the Lash Condo Law Blog. And she's also been qualified as an expert on condo law in the Ontario courts, and has also served as the director and officer and committee member for several organizations, and is currently the president of the Canadian chapter of the Community Associations Institute. So, Denise, thanks for carving out some time to speak with us today.
It's a pleasure being here.
We have a number of interesting issues to speak about today in the area of condo law. And the first is the issues involving Airbnb and the sharing economy. And as shown by Uber, the sharing economy is rife with legal and political challenge, and Airbnb is no exception. And a recent Ontario Superior Court decision has found that short-term leases of condo units can breach single-family provisions in condo declarations. And this decision is queuing up a host of other factors for condo lawyers to think about in advising clients, both unit owners and management. So, Denise, to start off with, can you give us a sense of what Airbnb is and what companies like these are doing to the condo landscape?
Well, similar to Uber, it's an online mechanism for finding, if you're looking for a place to stay or for leasing, a unit or a home similar to a hotel. Could be on an overnight basis, could be on a weekly basis. And so those condominiums in the city of Toronto that are located in really great tourist destinations are the ones that are mostly finding this a problem. And it's not just Airbnb. There are other companies that offer these short-term rental services.
And so is it essentially making your own place into a hotel for people to come stay in?
Well, that's the question. Because it's so new, like Uber, people are saying, how does it impact the hotel industry? Shouldn't there be taxes? Are these people taking in income that they should be declaring? So it involves a whole host of issues. The main one that we're concerned about as condominium lawyers is really making sure there's no breach of the condominium documents.
Now, I know that this issue we've been speaking about was one of the major cases that came up a couple years ago, well before Airbnb, involved a case called Skyline. Can you walk us through the relevant facts that were in place there?
So this was a case, it went to the Court of Appeal eventually in 2003, and they found in favor of the condominium corporation. It was a 189-unit building, and there were 94 units that were managed by a company called Skyline that were offering these furnished short-term executive rentals. And this condominium corporation had a declaration which didn't say anything about short-term tenancies, but it did say single-family use. And the condominium corporation, to deal with these short-term executive rentals, which the board didn't want to have in their condominium, passed some rules. And Skyline fought those rules in court, said that they shouldn't be enforceable. And the court found in favor of the condominium corporation, saying rules can prohibit short-term stays. And since 2003, we've seen a lot of this, that condominium corporations can pass rules. What you'll see in most instances are rules cannot be that units cannot be leased for less than 6 months. Some say less than a year. So if anybody has a lease term that's less than 6 months or less than a year, whatever the rule says, they're in contravention. You're thereby, prohibiting any overnight stays. It can't even be less than 6 months.
And is the intent of this not to have condos turn into hotels?
It's a lot of wear and tear on the common elements. All owners pay for that. Think about owners that move in and that live there. They don't want to be living next to a unit where there's always a different guest. We find that generally there's a lot of noise, parties, damage to elevators, damage to hallways. So, security issues. There have been many reasons for boards trying to pass these rules.
So that's a good precursor to the more recent case involving the Menzies case quite recently. Would you be able to tell us what that case was about?
Yeah, so it was similar. There was an owner who owned some investment units that they wanted to use for Airbnb purposes. And this was a case where, again, the declaration said single family use. And why this decision is important is that the court found in favor of the condominium corporation, saying that a declaration that says single family use means that it cannot be used for transient Airbnb purposes.
And what is the declaration exactly?
So a declaration is the condominium document that creates a condominium corporation. So when a developer sells to purchasers, they give them a set of condo docs in draft. Once the building is built, and normally it's occupied, and the city approves the condominium for registration, the declaration is the document that's actually registered in the registry office. And so it's like a corporation. You have the articles of incorporation. Because it's the document that creates the condominium corporation, has very important information in it, what your percentage common expenses are. And it can't be changed very easily. In certain circumstances, it can be changed with 90% consent, in others 80% consent. In this particular case, the court found that the declaration, even without rules, provided for it being a single family, and that a single family is really a one family residence and cannot be used for on a shared basis, shared rental basis.
So it seems like this case is a win for condo managers and developers. Is that right?
Well, for condominium developers, that's an interesting one, because a lot of condominium developers now prefer to have it open and to allow short term. So it depends who you're selling to. So if you're selling to investors, they like Airbnb. If you're selling to occupants, people who want to move in, owner occupants, they prefer not to have Airbnb. depending on the location of the building. So we are seeing more developers incorporating the provisions into the declaration to allow for transient use. And if you want to change that, if the board wants to change that, when I mentioned before about amending a declaration, they would have to go through the amendment, and that would be 80% consent of all the units.
And so what are things that condo lawyers should be mindful of in light of this decision and this line of cases, whether you're representing the managers or the unit owners?
Well, I think that whoever you're representing, you really need to make sure that these clients understand what's in the documents. Oftentimes what I see are unit owners who will buy a condominium unit and not really read them. They won't read the condo docs. The declaration is important and the rules. And I think that as lawyers, we really need to educate our clients as much as possible. I know that as lawyers, we're not often paid to do it. And I always say that people who buy condos, they're looking for the cheapest lawyer. They don't really want to pay to get someone to review their documents, but really, it can save you money in the end. So you need to look at the declaration to see if it's allowed, and then go further and look at the rules to see if there are any further restrictions. One could say one thing, and then it could be further restricted in the rules. And once it's in there, don't think you can get around it and get away with it, because you will be hit with legal fees. And the other thing I wanted to mention is the city of Toronto now is looking at putting in regulations, because the Condominium Act doesn't allow us to have any penalties to someone who does an Airbnb. We could just charge them the legal fees. If the city steps in, then we can, and imposes penalties, then there's a mechanism. So we need the city to help. The city of Chicago has recently, as of January, introduced ordinances, which are regulations, and they have actual prohibited buildings lists. So they have lists of buildings that allow short-term and lists that don't. And before you go onto an Airbnb, Airbnb is required to check with the city of Chicago to make sure it's on a prohibited or non-prohibited list. I don't know if that's going to work well. We hope it will, because there has to be enforcement. From a board perspective, and the management perspective, there are issues with Airbnb. And if the board decides that they want to stop these things from happening, they have to pass rules to make sure they're enforceable if they can. And if their declaration allows it, there are things you can do in rules to make sure that people are compliant. So if you have short-term tenants, you make sure there's registration. You deal with the fobs issue, entering and not using maybe the amenities. They can use the unit. So there are ways, and that should be dealt with. And also the board should be enforcing the rules.
In December of 2016, the Ontario provincial government provided a set of proposed regulations to be adopted under a new act known as the Condominium Management Services Act. Amongst other things, these regulations are to set out mandatory licensing requirements for condo managers, which could change the way that condos function and operate. So Denise, I know that this is one of many amendments that are being considered with respect to the Condominium Act. For people who may be unfamiliar, can you describe what condo managers do? Like, what is their job description?
Okay, so a condominium corporation is a condominium building, and that is created by the registration of the declaration. The developer will turn over the board to the owner elected board after a certain period of time. That board are usually volunteers, unit owners, but they don't have to be, that are elected to govern the condominium corporation, run a condominium corporation, reserve funds, operating funds. Obviously, they can't do that themselves, so they will retain a property management company. The developer will have a property management company in place at the time that the condominium is registered. And then the new board can decide whether they want to continue with that property manager or not.
Can you talk first about the driving force behind Bill 106, which set out this licensing regime, why this was deemed to be something that should be imposed statutorily?
For years, I think the whole industry has been trying to get the ministry to do something about the licensing of condominium managers. I think part of the problem has been that there's no governing body that deals with property managers, and which you have in most organizations and most fields. With the property management field, the managers and management companies that handle millions of dollars of funds, it's hard to believe that there hasn't been a governing body. There's been a lot of media attention over the past few years with some cases of fraud where managers and some companies have absconded with the reserve funds of condominium corporations, some of which we currently represent now. Their boards of directors that sometimes don't have any experience, may not have ever even been on a board. They rely on the manager. So the manager says, sign the check, they'll sign the check. And we are always saying to boards, it's really important to know what you're signing, to take, there should be measures in place to make sure that you do not give full control to the manager. Sometimes it makes sense to have a manager sign a check together with a board member because it will make sense in certain instances. But really, directors have to take a more active control. In my opinion, they need a professional property manager to run the condominium corporation. There's so much that has to be done. There's maintenance and repairs. There's collecting common expenses. There's potential renovations, establishing a reserve fund and doing engineer studies if there's deficiencies in the building. It's a whole host of things that really you need to have some kind of training or experience.
And under this status quo, what are the remedies, or what are the options for recourse if, a manager did one of these things that you were referring to, if they, absconded with funds or were deficient in their duties? Are there remedies that boards of directors have right now?
So right now, when you get a property management company to provide services, there's a management agreement. So it's a contract. And those contracts are really important to review. So these management agreements are not standard agreements. And you need to make sure there's things in there about privacy, PIPEDA, the obligations under various legislation, not just under the Condominium Act, reporting requirements, insurance obligations. You want to make sure that your manager has the appropriate errors and omissions insurance. And I've seen many contracts that don't give condominium corporations protection because they didn't review them. So, but that's your recourse. If it's a fraud situation, that's a different story. That involves the police, criminal charges, civil proceedings, perhaps.
What is the proposed licensing structure that's being proposed?
So there are going to be quite a few changes that you mentioned before, and we were originally told that it would be July of 2016. I think it'll be a phased-in approach. The first phase will be the introduction of manager licensing, and that can come, I think it's going to come as early as this July. So the licensing fees will be paid by managers, and some management companies who have 50 managers are concerned, how much will they be? There's a figure out there of $800. Will that be for the first year? Will that be every year? Nobody knows yet what the fee will be, but that's a real concern. And there will be a separate authority that will deal with licensing and will deal with the regulation.
What would be the criteria to become a licensed manager?
Well, there'll be those who have a particular experience or a certain education will be able to get their license upon payment of the fee. And if if it's somebody without experience, then it will be stipulated how much work experience and what kind of educational requirement that they need in order to get their license.
So is the intent of this process to more professionalize the process to ensure that we're going to have more competent?
I think that's the intention. The problem is right now, I think generally condominium corporations and their boards look to, of course they're concerned about what services they're going to get, but it's all competitive and they're looking at what is the lowest price I can pay for management fees. And I think that the mindset has to shift because now we have managers that are having to pay all these fees. Managers really don't earn a lot of money. Management companies struggle to find good managers because it's a tough job working for condominium corporations. And so if boards are not willing to pay for management fees, then they're going to have contracts that really don't pay much. And then the management companies in turn cannot really pay their managers that much. So the quality is affected. And so, how do you change that? And I think that the licensing is hopefully will be the start of a change, a positive change, and that maybe as an industry, we can educate board members to really value property management services, pay a bit more for it. You'll get better value. And then the managers will be paid more and it will attract better candidates into the field.
And appreciating that a lot of these regulations are still in the draft stage, what are things that lawyers should be mindful of? I'm thinking primarily if you're representing boards of directors.
Well, you're going to need to advise these boards that there's going to be a requirement for licensing. There may be managers out there, maybe individual managers that may choose not to comply. So there's a real concern because there's going to be stipulations for under the licensing regime for mandatory insurance. And we don't know all the details yet, but it's something that all boards are going to have to deal with. And I think in the end we'll have to pay and probably should be providing in their budget a little bit higher of a management fee. Because there will be certain stipulation, certain requirement for having a license that you have to go through all kinds of checks. So that will force these management companies and managers to be protected in such a way that this protection will be passed on to the condominium corporation. So the condominium corporation will have insurance to go after. These checks will be done. So hopefully you won't get a criminal who's running your condominium corporation and taking your reserves. There's, just like any regulation, there's in any legislation, people find a way around it and people breach it. But I think that this is going a long way towards helping our industry and regulating property managers.
Judgment rule is a fundamental principle in corporate law which provides that courts will show deference to the business judgment of corporate executives. This past fall, the Ontario Court of Appeal provided some meaningful guidance on how this rule is to be applied in the condo context, with respect to how directors can make decisions about their own buildings. So, Denise, before we get into this condo case, can you explain to us in more detail about how this business judgment rule works in practice?
What it means is that the decision of board should be shown some deference, and that what that entails is that boards make decisions, and it's not up to the court to interfere with those decisions as long as the decisions are made and they're acting reasonably and honestly and in good faith. And that's where that ties into the condominium setting and the Condominium Act.
I know that there was a recent case which the Court of Appeal provided some guidance on. Can you tell us about what the facts were?
So in this case, it was a condominium corporation that had residential units, but there was also a commercial condo owner who had all these parking spaces that they were using and leasing out on a monthly basis. What they wanted to do, this commercial unit owner, was to convert the monthly parking spaces into a pay and display hourly system. And by doing that, they would need to alter the common elements. And there's something in the Condominium Act that deals with any owner who wants to alter the condominium common elements has to get approval of the board and enter into a Section 98 agreement. And what happened is the board said, we'll agree to that, but we have security concerns. So we want you to employ a security guard to oversee the operation. And I think that was where the owner felt that was not justified and launched an oppression application. And that's under Section 135 of the Condominium Act.
And so what is this oppression remedy? How does it work in practice?
This oppression application is something that where you have to show that a certain conduct of a party, could be the owner or the condominium corporation or the board, acted oppressively or unfairly prejudicial to the party. There's something called, it's under the standard of care provisions, Section 37. It deals with the liability of directors. And when should a director be liable?
And so how did the Court of Appeal rule when this case, Carlton Condominium Corporation number 375, when this case got to the Court of Appeal, what was the decision?
Well, the decision was in favor of the condominium corporation. So the corporation lost at the level of the Superior Court, where the owner they found in the owner's favor. But then the Court of Appeal talked about the business judgment rule. And in this case, they felt that the board had reached a decision that was within the range of reasonable choices. And they didn't feel that they acted oppressively. And so I guess that's the question when boards make decisions. Are they making a reasonable decision based on the circumstances? The Condominium Act specifically has provisions that say if you act honestly and in good faith, if you rely on professional opinions, then your decision really should stand. It's complying with the Condominium Act. And what the courts are saying is the business judgment rule should apply. Let's not interfere with the decisions of the board and let the board make those decisions. The boards can be wrong, but as long as they acted reasonably, then that should stand. The court also found that the fact that the board made a decision against the interests of the unit owner doesn't mean that that decision should be overturned by the court, because it's a hard job being on the board, that you're weighing the interests of different owners. And I think when I look at what the board did in this case, they felt that their security was a real issue. And so that's what they were weighing, those interests of either party. And they felt that they'll agree to the pay and display, but they want the security. A reasonable decision, I think.
If you're a lawyer and you're advising a board of directors with respect to decisions that they're making or planning on making, what are things that they can be doing to ensure that they are meeting this threshold and that their decision will be protected by the business judgment rule?
Yeah. So what the board wants to do is, before they make a decision to approve or not approve a certain matter, a certain request by a unit owner, usually you run it by the property manager. Property managers will, hopefully, if it's a licensed property manager 6 months from now, will know when it's appropriate to get professional advice. It may be that it's an engineer's advice or an auditor's advice or lawyer's, but that is essential because we have seen situations where boards do not get proper advice and they will be personally liable. Another thing to mention is what's mandated by the Condominium Act is directors and officers liability insurance. Every condominium corporation has to have it unless there's a reason why you can't get it. And the directors and officers liability insurance will only cover you. And personally. If you've met the standard of care that I mentioned in the Condominium Act, you have to act honestly and in good faith. You rely on the professional opinion. So even if the lawyer is wrong, if you relied on it, then you're covered and you're protected personally.
And what about on the flip side, if you're a unit owner and you're filing the suppression, or you're considering filing the suppression application, is there a requirement that they get a professional opinion from a manager or someone else?
It's not a requirement, but if the court finds in favor of the owner, and they didn't rely on a professional opinion, these directors could be personally on the hook. So, that's something that, as a unit owner, I don't think you would look to see whether they received the professional opinion or not. It still wouldn't, you'd still have a claim against the corporation if they acted oppressively. So they could have gotten an opinion, but still acted oppressively.
Are unit owners right to be concerned? Because it seemed like this position gives a lot more credence and a lot more authority to boards of directors, which may seem to, swing the balance more towards the board side. What do you think about that?
Yeah, I think that this does shield directors in a way, but it only does that if these directors act honestly and in good faith. And I think that's important because oftentimes it's hard to get good people on boards, and you want to attract good people. And so if you want to know that if you get on the board, that there is some protection for you if you act honestly in good faith. And of course, that's the key here, in that if this board did not act honestly in good faith and did not meet the standard of care, the court would have decided differently. And they would have found in the owner's favor that there was oppressive conduct. But that wasn't the case here. So I think there's still protection in the Condominium Act that if directors are truly acting oppressively, then unit owners will be successful in oppression applications.
Great. So Denise, I want to thank you again for your time on this subject. As condo issues are becoming front and center in our news, especially in major cities. And I think that your guidance will be very instructive in a lot of issues going forward. So thank you again for your time, and we look forward to staying in touch in the future.
Thank you.
And that's a wrap for episode 28 of Lawyered. Thanks for tuning in. My guest for today was Denise Lash, and you can find out more about her practice, and her blog at her website, which is lashcondolaw.com. And for more about today's show, and for links to all the cases that we talked about today, you can find those on our website, which is lawyeredpodcasts.com. Next time on Lawyered, I'll be speaking with international trade lawyer Jessica Horwitz, and we'll be speaking about trade remedies and Donald Trump, federal anti-corruption legislation, and the new Canada-EU Free Trade Agreement. Our show's music was provided by Ben Swirsky, and our website was designed by Jenny Zhang. And to make sure that you never miss another episode of Lawyered, you can go ahead and subscribe to this podcast for free on iTunes or your favorite podcast app. And as always, you can follow our show on Facebook, LinkedIn, or on Twitter. And our Twitter handle is @LawyeredPodcast. And as always, please be advised that while this podcast is aimed to be helpful and informative, that it is not intended to be legal advice. However, if you do want legal advice, please reach out to a lawyer directly to help you with your particular situation. And with that, we'll see you in 2 weeks. Until then, keep it legal.